Hello and welcome to this video about the Occupiers Liability Act 1984. When answering a question on the 1984 Act, you start with the same three elements that you used for the 1957 Act. First of all, you need to show who the occupier is, which is someone with control. Then you need to show that the person is not a lawful visitor, i.e. they are a trespasser, or they have exceeded their permission, so they might have started off as a lawful visitor and then gone beyond a door saying staff only, or gone beyond a warning sign or a door that's locked maybe. Then you need to show what the premises are, a fixed or movable structure including a vessel, vehicle or aircraft. So sometimes if you have a scenario that has got both a lawful visitor and a trespasser in it, you may be able to save time by doing these elements together. The fourth element is the same as well. The damage must be caused by the state of the premises, but there is a different case applicable for the 1984 Act. So the duty, just like for the 1957 Act, is in respect of any danger due to the state of the premises, which means that the premises themselves must be inherently dangerous. And in Keown and Coventry, the fire escape itself was not dangerous. It was the claimant's decision to climb on it and then fall off it that caused the danger. So in a scenario question, you might find that the trespasser is just doing something stupid and there's nothing actually wrong with the premises. If you do think this is possible, state it, but then go on and consider the other aspects of the Act to make sure that you get all the marks. But this is not enough to prove a duty. It would be for the 1957 Act, because once you have got those first four elements, you have a duty. But it's not the same for the 1984 Act. Because it applies to trespassers, it's much stricter. So you also have to show all of the things in section 1.3 A to C. And this is a common mistake in the exam, is not to deal with all of them. So once you have got your occupier, unlawful visitor, premises and damage caused by the state of the premises, you need to consider section 1.3a. And that is that the occupier must be aware of the danger or have reasonable grounds to believe it exists. And in Rhind and Asbury Water Park there was no liability as they didn't know that there are any objects under the water. Next you have to look at section 1.3b, which is that the occupier must have reasonable grounds to believe that the other is in the vicinity of the danger. This is a bit strangely worded. The other is the trespasser, and in the vicinity of the danger just means near the danger. So they have to know that the trespasser is near the danger or have reasonable grounds to believe that they are. So in Swain and Natui Rampuri, the occupiers did not have reasonable grounds to believe there was anyone in the vicinity of the danger, because they had large fences around their factory and there had been no evidence of previous trespass. So they had no reason to think that particularly a child would be climbing on the roof of their factory and falling off. By contrast, in Scott and associated British ports, the occupier was aware that there had already been instances of train surfing, people jumping onto the train. And so when it happened again, they couldn't say they didn't know it was a possibility, as it had already happened before. They were already on notice of it. So they potentially were liable. And then the last thing is in section 1.3c, the risk must be one which in the circumstances of the case, the occupier may reasonably be expected to offer the other some protection. The leading case on this is Tomlinson and Congleton Borough Council, which is a House of Lords decision, very important decision, and they said the council did not owe a duty to a man who ignored no swimming signs and dived into a lake and consequently became paralysed. It's unreasonable to require the council to protect the claimant from himself. There is no duty to safeguard irresponsible people against obvious dangers, and that is a good quote to use in the exam. So in a scenario, you need to consider all three aspects. Was the occupier aware of the danger or have reasonable grounds to believe it exists? And you'll be given a clue sometimes about this. Did the occupier know or have reasonable grounds to believe someone was near the danger? So sometimes they'll say that they were aware that people had been breaking in or that teenagers had been trespassing, and then they are aware. And then under C, is it reasonable to offer protection? You might like to consider the purpose of the entry. So a burglar would be given much less consideration than an innocent trespasser. The age of the trespasser, obviously someone young, a child, is going to be given more consideration. The size or nature of the occupier, a large company with a lot of financial resources is going to be expected to do more than just an individual. And what precautions were practical? Was there anything that could actually be done to have made the premises any safer, or were they too large? Once you've considered whether there is a duty at all, and as you can see that is where most of the marks are, the duty itself is in section 1.4 and is to take such care as is reasonable in all the circumstances of the case to see that the trespasser does not suffer injury by reason of the danger concerned, and this is a lower duty than that owed under the 1957 Act. For breach, all you need to say is that the occupier must reach the standard of the reasonable occupier. You don't need to worry about the risk factors. Then you need to consider section 1.5. So everything you need is all in section 1 of the 1984 Act. So under section 1.5 you can discharge the duty by taking reasonable steps to give warning of the danger or to discourage people from taking the risk. So a warning doesn't have to be such as to keep the trespasser safe like in the 57 Act. It just needs to make the entrant aware why he or she should not enter. When considering whether an occupier is in breach of his duty, the occupier should not have to guard against an irresponsible and determined minority. Platt and Liverpool County Council. That's quite a useful quote as well. Discouragement in section 1.5 just means things like having a fence or having locked doors or barbed wires or a guard dog or something like that. Any sort of discouragement, a wall or fence round the premises. So to finish off an answer, it's similar to the 57 Act, only deal with causation if there is a specific issue, such as the thin skull rule that has been given to you in the scenario. The defences are more likely to apply in a trespasser scenario, so either contributory negligence and more likely consent or valenti if the claimant knew of the risk and voluntarily accepted it. And for these purposes, for the 84 Act, Ratcliffe and McConnell is a good case where the man was held to have consented when he trespassed and jumped into a swimming pool that had very little water in it. Lastly, mention the remedy. It would be damages, but you don't get damage to property. So sometimes in a scenario they will mention that someone has damaged their watch or their phone, and if it's a trespasser then they're not going to be able to claim for that. So these are the key cases. See if you can now remember what they are. And that's the end of this video on the 1984 Act.